Today we're going to focus on just some essentials of IP that really apply to life sciences companies as well as other companies, and some of the specific issues that are faced by life sciences companies. Let's see. All right. So life sciences is a very technology-driven industry. I think we all know that. And I think the reason being is that life sciences makes people's lives better. And so there's no better place to invest time and effort in moving technology forward than in places where you can make people's lives better. And the way that's typically done is through efforts in research and development and in manufacturing. And those two areas of business are just chock full of intellectual property, specifically patents and trademarks. Now, that's not to say that life sciences companies don't have all other forms of intellectual property. They certainly do. If you take a big pharmaceutical company, they spend probably hundreds of millions, if not billions of dollars in branding and marketing and other efforts that result in different forms of intellectual property. But I think for today, what we want to talk about is that intellectual property that focuses on the core technology of life sciences firms. Talk about what it is, how to identify it, how to make sure you can protect it so that in the future you can enforce it. Because IP is all about playing the long game. You're not going to make all your money off IP in the beginning. You make the money off of IP when you play the long game, because in the future it gives you a leg up in competition. So we'll go over all that. But at a high level, I'd talk about what patents and trade secrets are. Patents are a protection for inventions. Patents are a government-issued monopoly that's given to an inventor or an assignee of an inventor for any new, useful, and non-obvious process, machine, composition of matter, or article of manufacture. So there's a nice list that's been given to us by the federal government for what types of technology qualifies for patent protection. And all of those fields are seen in the life sciences industry. Processes in life sciences are things like how to identify whether an infection is viral or bacterial, so that you can understand whether or not someone needs to be prescribed antibiotics, or whether or not you can avoid that, how quickly you can do that so that the decision can be made at the doctor's office. Articles of manufacture are things like implantable devices that are used every day in hospitals to make people's lives better. Machinery, the scanners in the hospitals, compositions of matter, pharmaceuticals, and even genetically engineered plants. So all those core inventions can be protected by patents. Trade secrets, on the other hand, are a little more loosey-goosey in the definition. Trade secrets can cover pretty much any secret that's not generally known and from which a business can derive value. Now that you see it a lot in manufacturing, the know-how that goes along with how to take a product from the lab to the shop floor effectively so you can scale up. You also see it in business strategies, how to get to market, and in all sorts of financial areas and how a business is going to move forward, all of which is critical to the life sciences industry. So the first step for protecting intellectual property is to identify what intellectual property exists for a life sciences company. Life sciences companies generally know what types of inventions they have that at least could be the subject of a patent, right? They know what they're working on. They know where their efforts are being spent. And so usually the focus on identifying inventions in the life sciences space is not, hey, what are we doing that could be the subject of a patent? It's what are we doing that we know can't be the subject of a patent? And that's been the focus of some recent Supreme Court decisions, which have held that things like abstract ideas, laws of nature, and natural phenomena are not subject to patents. One good example is up until about 2013, the United States Patent and Trademark Office issued thousands of patents on human genes. And the result of those patents was that the holder could limit others' ability to use those genes commercially or even in the lab for future research. And in a case called Myriad Genetics in 2013, the Supreme Court said, no, that's not patentable subject matter. Genes are a product of nature. They exist. They existed before you identified them, and the mere fact that you've identified them, all you've done is recognized a law of nature or something that's naturally occurring. And so we're not going to allow that to be considered patentable subject matter. But when you go beyond just identifying something or progressing science to a better understanding, that's when you get into patentable subject matter. My background is I was an engineer, and I remember in engineering school, one of my professors tried to explain the difference to me between a scientist and an engineer. And what he told me was that a scientist comes up with the laws and the theories that help us understand what's going to happen if we do something. And what an engineer does is he takes those laws and those principles and applies them in a real-world way to make a product or a process that can be used to help people. And so I think that's a good, clear line. I think that applies here to patentability as well, because just identifying new science isn't enough. You've got to apply that science to something to create an invention. Where you see it getting a little hairy is in living organisms. That's another thing, kind of like DNA. Originally, the thought was that living organisms aren't patentable. But then I think it was about 2008, there was a case called Diamond versus Chakrabarty, when an engineer from General Electric developed a new sort of bacteria. Now, that bacteria existed in nature. And that bacteria naturally wanted to eat oil. Don't ask me how it ate oil, but it did. And it broke it down and got rid of it. But the problem was, when that bacteria consumed the oil, something within its genetic structure told it, you need to slow down. Maybe that's not good for you. Maybe it affects the reproductive system. But naturally, the bacteria slowed down from that consumption. Well, there was a professor named Chakrabarty from India who realized that if a certain gene was turned off in that bacteria would never slow down. And so it became a very effective way to combat oil spills, because they could put the bacteria in the ocean, it would consume the oil quicker, and it was natural, except for the fact that it had been genetically modified. And the Supreme Court said, yes, while that is a living thing, and while the bacteria originally existed in nature, what is patentable is this modified bacteria, because it's not found in nature. It's new. That's one of the requirements for patentability. It's non-obvious. No one thought it was obvious to genetically modify bacteria so that they would be better at consuming oil. And it's useful because it consumes oil. So that was a big change in the law that really can be applied to the life sciences industry. Let's see. Trade secrets. Trade secrets are, like I said, a little more difficult to understand what can qualify as a trade secret. It's more of a case-by-case basis, and a lot of life sciences companies don't really know what they have. They know that they've spent a lot of time and a lot of effort trying to figure out how to make a product or how to develop a process and take it from something that they think will work into something that will work. And sometimes the result of all that effort is not patentable subject matter, but it is something that it would be very difficult for others to figure out how to do. And so as long as the life sciences company can keep that a secret, that can be a form of intellectual property that can be enforced against others if it's wrongfully misappropriated. Questions to ask yourself when you're looking for this type of intellectual property is whether competitors could benefit from this knowledge. How much did you have to invest to get there? What did you need to learn to get from the lab to the shop floor? And another big question with trade secrets is how easily can this technology be reverse engineered? Because the threshold level or the threshold question for trade secrets is whether or not this can actually qualify as a secret. If someone can easily reverse engineer it and figure out what you're doing, it can't be a trade secret. Almost forgot. I did want to touch one more thing on identifying inventions. When you identify inventions in life sciences, identifying inventions is more than just what do we have here. It's also when do we have this subject matter in a form that's ready to be given to the United States Patent and Trademark Office such that we can get an enforceable patent, right? Under our current laws, there is a race to the United States Patent and Trademark Office because the law says the first person to file an application directed towards an invention is entitled to the invention that results from the application, even if someone comes in a day later, right? And that's a new procedural law, but effectively, being first has always been important to patentability because what you've always had to show is that your invention is new. And if someone else is already doing it, then your invention can't be new. And so there's always been this rush to get to the patent office. But that's got to be balanced by identifying when you're actually ready to go there. And that's another issue that's come up very recently. As a matter of fact, it came up after I prepared these slides. I'm sure all of you are probably familiar with a company called Gilead. I think I'm pronouncing that correctly. But what they did was they created a treatment that could be given to people who have hepatitis C, a viral infection that had been incurable. I think there were two treatments, Harvoni and Sovaldi, if I remember correctly. But anyway, they're about $30,000 a course, and I think the effective rate is extremely high, especially for a disease that was considered to be incurable before then. In 2013, a Merck subsidiary, after it had recently obtained 2 patents on very similar treatment, asserted those 2 patents against Gilead in the District of Delaware. After 4 years of litigation, Gilead's back was against the wall, and they had to essentially admit that their products infringed. And they had sold billions and billions of dollars of these products. And they went to trial on 2 issues. 1, damages. What do I have to pay? And 2, the written disclosure was inadequate for the Merck subsidiary to be entitled to a patent. Well, the jury found liability. $2.54 billion, as a matter of fact, in liability. It's a big case. I'm sure some of you have heard of it. That was in January of 2017. And in addition to that, the jury also found that the written description was adequate, that a person of ordinary skill in the art would know what to do with this disclosure in order to make this, in order to synthesize this product that had a methyl group in the 2-up position, whatever that means. And so the verdict came in, and the judge put it up, and about a month later, the lawyers for Gilead said, well, wait a minute, Your Honor. We think you need to take another look at this disclosure. And so he did. And over the course of the next nearly year, Judge Leonard Stark, who's an excellent judge in Delaware, tries a lot of patent cases, decided, based on his review, now keep in mind this is a judge reviewing a biotech patent, a judge with a legal degree and probably a liberal arts degree, reviewing the patent and the evidence that was presented at the trial, and determined, based on his review, based on the law, and based on laws that he had passed since the date of the filing of that lawsuit, that those two patents were invalid because they failed to disclose to a person of ordinary skill in the art how to actually synthesize this nucleoside. That's huge. That's $2.54 billion wiped off the books of this Merck subsidiary. And so that's another very critical aspect of identifying inventions, identifying when you're actually ready to take what you think is true in the lab and put it on paper and send it to the patent office and describe what you're doing, why what you're doing is going to work, and how what someone else needs to do in order to do the same thing. Because that's the quid pro quo for patents, right? If the government's going to give you this monopoly, what they want in exchange is for you to disclose all of this technology to everyone else in the world so that this technology can be built upon, right? That's how it progresses science. And so if you're not able to tell someone how to do this, then you're not ready for a patent. That also brings up another point. It would be very advantageous if you could continue to do what you're doing without disclosing what you're doing to others in a patent application. And that's where trade secrets come in. With a trade secret, you don't need to disclose your secret sauce. So long as you can keep it a secret and you can keep it from others, you're allowed to enforce that trade secret and prevent others from practicing it who have misappropriated it. But keep in mind, if they can reverse engineer it, then they're not prohibited from practicing that same invention. And so that's a big takeaway is, when do you choose which strategy to employ? And the biggest question is, can you actually keep it a secret? Once you've identified the intellectual property that you do have, one of the big keys to enforcement is proving that you own it. You know, most people in their heads think that intellectual property is created by a guy in a garage, and so there's no big issue on who's going to own this. Who owns it is whoever the guy says is going to own it. But that's not actually true. Usually, patents are the result of collaboration between several individuals. Normally, several individuals in one company. And that's the easiest way to prove ownership. But the default rule in the United States is that just because someone is employed by a company doesn't mean that the company owns the patent that results from that employment, right? In order to own it, what you need in place are contracts with those employees. And those contracts need to obligate that employee to actually assign his rights in that patent or her rights in that patent to the life sciences company. But there are a lot of other contributors to this IP. For instance, what you see a lot are subject matter experts that are hired by life sciences companies and other independent contractors in manufacturing and other areas that can make some pretty material suggestions to the technology that's being developed by the life sciences company. And the default rule in the United States applies to those folks as well, to the extent that they're contribution was material, and that it advanced the ball, and that it's encompassed in these claimed inventions, you've got to be able to demonstrate that those individuals have also assigned their rights to the life sciences company in order to prove that you've got an enforceable IP position. Now, collaboration doesn't just come from employees and independent contractors in today's world. I think what we see more and more is there is a lot of joint development that goes on between companies, between Greenville Hospital and maybe some startups in the area. And the law now allows for that type of joint development to occur and not to be used against someone who's applying for a patent, which prior to that it could be used because it'd be hard to show that it was either yours or that it was new because someone else could stake a claim to it. And so it's important to understand that if you're going to enter into some sort of joint collaboration with someone else to develop this intellectual property, that you need to have what's called a joint development agreement in place to demonstrate what's owned and who's going to own something in the future. You know, usually you bring in what you have, the other person brings in what they have, and then you have an agreement that dictates who's going to own what's developed going forward. Trade secret ownership is more about having reasonable measures in place to demonstrate that this stuff is a secret, and I'm able to keep this a secret using certain techniques that I've employed at my business. That includes things like employment agreements and independent contractor agreements that have confidentiality provisions. But more importantly, what that includes is a trade secret policy and procedure that you follow. And it shows, number one, your employees, here's what you need to do to protect this stuff. So that's one key to it. But even more than that, to win a trade secret case, you've got to demonstrate to a jury that what you're doing is effective and reasonable. And so when you draft these policies and procedures, you've got to draft them with the mindset that this is going to be shown to a jury. You've got to articulate why it's effective, why these measures are reasonable, and why this misappropriation never should have happened. I'll be quick with the last two, I promise. All right, why are we doing this? Well, the whole reason why intellectual property is so important in the life sciences space is because IP is value to a life sciences company. IP is the long game. In the long run, your competitive advantage is going to be there if you have secured your intellectual property in a way that either prevents competitors from competing with you by way of a patent or paying a royalty by way of a patent, or prevents them from learning what you've learned in order to get a product to market cheaper or quicker. And so we see this in the long game, but we also see this in the short game because I think, as we all know, a lot of mom and pops shops don't exist in life sciences. Small groups just aren't here. You sink or swim in it, and it happens quickly. And if someone's really doing well, what's going to happen is they're going to be acquired, or at least someone's going to invest in them. And if you want to have the highest valuation for your company, it's critically important that you're able to showcase your IP during due diligence, right? You want to show that you have everything in place that's identified it, that it's in an enforceable position because you own it, and that you have your documentation in a row so that when it comes time to assert it against someone else, you can prove an enforceable IP position so that in the long run, your products can be sold either exclusively or at a major competitive advantage versus your competitors in the future.
Thanks, Sam. Good to see everyone. And I'm going to call back to Stephanie's, and I'm your proverbial rat jumping off the building portion of the session today. So when Sam and I were talking about this and what, I was like, are you sure you really want me here? Because these are like really smart people that are delivering amazing messages, and you're going to put me up there with them. And he said, yes, I do. So here we go. Yeah, as Sam mentioned, I'm playing in this space, and I love it, and I'm passionate about it. But one of the things that I'm seeing out there in the state as I continue to work in this sector is some definitions that we should clarify. And certainly as I look at innovation and entrepreneurship, they're not the same. So let's be very elementary. I'm going to give your brain a break from all the deep knowledge that you're getting imparted on you, and take it high level. Innovation, the introduction of something new idea, method, or device. And Sam mentioned collaborations. I just saw an article today in the Charleston Business Journal about a collaboration between Clemson and MUSC that have created a new operating room environment. And I'm going to read right from the article about what they're doing. It says, in an effort to design an operating room that increases patient safety and easier for doctors to use, MUSC been working with Clemson on a 4-year project which began in 2015, which I didn't even know, to study how doctors maneuver around the operating room. The idea here is not to just look at the design or come up with a nicer looking OR, but to really understand how do people work in the spaces, what are the concerns, and to be sure that it's not just related to the design. So when I think about that, it's really cool to think about how inventions come and how innovators think about the world differently. And so I go back to Edison's light bulb and thinking about how he probably saw the world and wanted it to look differently than how it was currently looking. As we look at innovation and think about it and apply it to what we already know and some baseline of activity going on, not all innovations actually have to be brand new inventions. They can be iterations on things that currently exist. So we think about the transition of, the evolution of the light bulb since Edison's first iteration of it. Same rings true. So for this life sciences industry, a lot of that activity is going to be done in research labs, and it's going to be figuring out new iterations on stuff that already exists. And that can become great innovation. You heard all the potential pitfalls that come from the application process, the legal process, structuring it, but the innovators are the ones that see the world and still are going to push the needle forward even despite some of those challenges of how you take that from idea to actually commercialization. I see, going to that reference article, I see robotics being such a big play in how things continue to evolve in this sector and obviously our manufacturing sector in the state. So important to understand innovators, and a lot of times they are working on these things and they're iterating on these things constantly, and they're testing it and they're trying it and they're breaking it and it's not working, but then they do it again, they do it again, they do it again. So that's really a core functionality of innovation, and I think it's important, and I see my partners at Commerce in the room, that not all of these things are going to work the first time. If it happened that way, it was too easy. It's going to take testing, it's going to take trying, it's going to take iterating. So now let's talk about these mystical creatures that we call entrepreneurs. So it's also equally important to understand that entrepreneurs, and Sam and I have talked about this, is, we say at the harbor, we're literally throwing a dock party at the end of the dock that doesn't exist yet, and we are just putting the planks down as we're corralling the people to come have the dock party. We're building it as we go. As you see here, similar analogy, someone who jumps off a cliff and builds the plane on the way down. These are crazy people, but they play an important role in the ecosystem, as do the attorneys that help structure things, as do the regulatory guiding Sherpas, as do the inventors. The entrepreneurs also play an important role in the ecosystem as we look about building this life sciences industry in the state. So Sam asked me to talk a little bit about my journey, which I don't like doing, but I'm doing for him. And so 4 years ago, Patrick and I had a crazy idea to start this accelerator program, and I see Chelsea in the room who actually participated in that first program 4 years ago. We literally had not mapped out anything other than the first 6 months. Like, let's just try a thing and let's see if anybody will care. And I think that's a important sort of mindset to understand about the entrepreneurs and how they view the world, is that they're willing to try and take the risk and do it without knowing all the potential shortfalls that could derail them. So, the good news about our journey is it started to work and people started to care. And so after we launched that first accelerator program 4 years ago, we started bringing more things to the entrepreneur community. And, the one with Patrick and I and Brandon was from the first startup weekend that was hosted in Charleston. And then Dig South comes along, and this is a tech conference if you've not been to, you should certainly have on your radar. Our team has won the first pitch and then the second pitch, and so we started to see traction there, and they started getting money. We started actually writing some checks into companies that were coming out of our accelerator program and supporting that. And then I have been fortunate to be able to start traveling nationally to understand how these ecosystems are being built across the country. And so, being at the New Orleans Entrepreneur Week with Steve Case, the co-founder of AOL, and then, Jackie and I went up to New York and participated, in the Accelerator Alley in the largest startup conference that they've ever had up in New York. 30,000 people that were there, which was pretty crazy. The cool part about that is we found people that said, "Oh, you're in South Carolina?" Like, I had no idea there was anything going on there, and we started bringing people and introducing companies to the potential of moving to South Carolina. And then just a few weeks ago, I was back in D.C. with Steve Case in their Rise of the Rest Summit. Cool fact to know, so it's certainly relevant in this industry. So Steve and team raised $150 million from LPs like Jeff Bezos and the co-founder of Carlyle Group and Bill Gates. And so these are the LPs in this $150 million Rise of the Rest fund. I'm proud to say that in their first tranche of investments out of that fund, one of those was a South Carolina-based company that we invested in and teed up. So it's a really neat development to see how this is evolving, and now knowing that we're going to be on the radar to bring other money from outside of the state into investing in companies that are growing here. So, we heard a lot about sort of recruiting in. We're doing a lot of work, and there's a lot of efforts underway to move the needle from the ground up, and hopefully we can continue to start playing together. It's also important to know it's not all glamorous. I mean, the entrepreneur journey is a rough one. There are the highs of being in the conference room and being able to hang out with Steve Case, and then there's the other reality of you're ripping up carpet at 10 o'clock at night because you got to get floors laid down in your new building the next day. So this is a very consistent attribute of the entrepreneur mindset, that is, they will just do whatever it takes and they will keep grinding in order to move their initiative forward. The path is also not a linear one, so the winds are going to change, your operating environment's going to change, but the fun part is that as long as you can embrace the journey, then it really becomes a satisfying, sexy lifestyle. So I'm sorry, the one that can't be displayed is one of my favorite images, which is from Kevin Spacey. And it says, if you're lucky enough to achieve a level of success, it's your obligation to send the stairwell back down. And Sam and I have talked about, on a state level, sort of the assets that are here and the acumen and the knowledge base and the experience of people who have come to our state, both, certainly upstate and low country area, and in the Midlands too, but primarily in those regions. we have an untapped asset in my mind of these amazing experiences and people with knowledge and know-how that can contribute to the future of building the business of life sciences in our state. And so it's a mindset that I think we can adopt and try and engage a lot of these people that have done well, other parts that are now living here because they want to be here, but can contribute to the development of this ecosystem. So with that, I'm keeping us on time, and I'm going to answer a couple of questions if anyone has any. Kat.
What's the most important advice you can give to an aspiring entrepreneur?
Build your team. I mean, you heard all the different, it's unrealistic to think that you're going to do it all. So the faster you start to recognize the skills that your company is going to need and begin to build the team, whether that's paid partners, contractors, etc., all part of it, start surrounding yourself with the experts and the people that can help you move it forward. The best CEOs hire people way smarter than them and get that team going as fast as possible.
As you talked in early on, that in the last 5 to 10 years, we found kind of that entrepreneurial innovation kind of space in the state, and definitely there's pockets around. What do you see the factors that have contributed to accelerating or making that foundation today, and what are the factors that will take it to the next level?
Yeah, I call it our Mount Rushmore. Certainly if we talk with the tech sector, software sector, we've had several exits. 20 years ago, Blackbaud, Benefit Focus, automated trading desks start in Charleston, and Blackbaud, Benefit Focus go public, and automated trading desk sells for $680 million. So the liquidity events there, plus the seasoned experience of those executives now starting to pour in, you see that second tranche of companies. Now we have, I know of personally, over $100 million of invested dollars in software companies in the Charleston area. So as those companies sell, and we're starting to see it, then all of a sudden that just widens, and now we're in that sort of third tranche. The second is the maturation level of the both ecosystem and support networks. So you heard from really smart people earlier today, as we continue to just pour smart people into this and connecting dots, that those pathways, I've already seen it in 4 years, from the applicant pool into the accelerator. Like the level of sophistication that the companies, they're coming in asking better questions, they're working on bigger problems, they have greater opportunities. So I only see that continuing as things like this and people get continually connected.
What are the differentiators, or if there were one or two that South Carolina possesses, you think, that can help, build on Eric's question, help us go to the next level, attract more capital, attract more interest? Is part of it even quality of life and our ability to recruit the creative class here?
It is. I mean, with the cloud, you can build a lot of these companies from anywhere. Remote workforce is going to be a big part of sort of the next generation of how companies operate. So having a great place to live is going to be a key asset. The other is we're not so mature that you can't break into the system. Right? You can come into a room like this and you connect with 15 people that are going to actually help you move forward. In these bigger markets and more mature ecosystems, it's tough to crack that nut. So I think that becomes an advantage for us, for anyone trying to move something forward, is we can integrate them and connect them into the right people. And that's why I'm so thankful and passionate about what you're doing with this organization.